Same-sex couples who were wed in Indiana 2 weeks ago say they're disappointed and disgusted by Governor Pence's decision not to recognize their marriages. The governor Wednesday ordered all state agencies to act as if the ban had never been lifted, essentially making them ineligible for any spousal benefits. Gretchen Frazee reports on how Pence's decision further complicates what rights newlywed same-sex couples have.
I now pronounce you married.
Hundreds of couples rushed to county courthouses late last month, minutes after a U.S. District Court judge struck down the state's ban on same-sex marriage.
Jake texted me and said, "Do you want to get married?" And I thought he was joking, and I hadn't heard the news yet.
After receiving marriage licenses, many of those couples married on the spot.
We just got married, which is amazing.
Well, by the power finally, at long last, vested in me in the state of Indiana, I do declare that you are spouses for life.
We're just married all of a sudden. We don't even know what to think.
We have no idea what's next.
I now pronounce you married. Yay!
We're doing something that was illegal 2 hours ago. Like, it's just crazy how times change.
I feel like we're recognized. And I know it just happened a few hours ago and things might change in the next couple days, but I feel like eventually it's going to stay.
Just 2 days after Sarah Perfetti and Abby Henkel's wedding, an appeals court halted all same-sex marriages in the state until the court rules on the appeal. This week, the governor's legal counsel said the state would not recognize the marriages performed during that 2-day window. In a memo, attorney Mark Ahern wrote that the state's marriage law is in full force and effect, and executive branch agencies should act as though the original court ruling was not issued.
I mean, the fact is that it did happen, and we have a marriage certificate, and it has the state seal on it. So whatever they want to say about state laws, we're legally married. And the federal government recognizes that, and our parents recognize that, and I don't really think it should matter to anyone else.
And despite the state's decision, Perfetti says they still plan to have a large wedding reception at her parents' house in Northwest Indiana next month.
Governor Mike Pence told reporters this week that it's his duty to uphold the laws of the state. And since his legal counsel told him the judge's stay left the state marriage law intact, the state should not recognize those same-sex marriages. Now, to discuss the important legal consequences that decision has for same-sex couples, we're joined by Steve Standers. Steve is an associate professor with the WTIU Maurer School of Law. Thanks for joining us.
My pleasure.
So if we can just first begin by talking about, in a practical sense, now, what are these same-sex couples ineligible for that they were eligible for prior to this?
Well, the vast majority of rights and responsibilities that go with a marriage license are created under state law, created under Indiana law in this case. So that means that, for example, if a spouse were to pass away, a legal spouse would automatically inherit from the other spouse. If in the absence of a will, for example, that right wouldn't apply. The right to make medical decisions for an incapacitated spouse. There may even be confusion and difficulty if there are children involved about whether or not the parent who thought that they were married is a legal the spouse who thought they were married is a legal parent of the child of the person that they married. So it breeds a lot of confusion potentially.
And then what about on a federal level? Because that's different too, which further complicates it.
That's right. There are also a significant number of responsibilities and benefits that go under federal law with marriage. For example, the ability to inherit your spouse's Social Security pension if you pass away, the right not to have to testify against your spouse in certain kinds of federal court proceedings. For example, there are actually over 1,000 areas of federal law where marriage is implicated. The Obama administration has said that couples like those married in Indiana and Utah and Michigan and other places where we've seen this same issue come up will be considered legally married for purposes of federal law.
So even though they won't be eligible for those state benefits, the federal benefits are still intact.
That's correct. And it points up what I think is an anomaly or a difficulty in the governor's decision. Essentially, the governor has taken the position that these are not valid marriages. That must be the implication of his decision. Well, the federal government thinks they're valid. The Seventh Circuit, the Court of Appeals, when it stayed Judge Young's decision, it didn't say Judge Young was wrong. It just said we shouldn't proceed any further until the Court of Appeals has had a chance to review this question. So I think there's a significant issue about whether the governor is actually on firm legal ground here or not.
And we don't have a lot of time for this question, but I do think all of this begs the question, should we be fighting this? Should the governor and should the attorney general continue to fight this when we see the way the tide is turning nationally? I mean, we saw this in Kentucky after Indiana's. And
well, I think it's quite likely the Supreme Court will have to take up this question in its term that begins in October, and we could possibly have a nationwide resolution to the issue a year from now. But in that year period, there are many of these couples may have things that come up that happen in their lives where marriage and the legal rights of marriage are significant, and they may not want to wait.